Hello and welcome to the in-depth series of Drishti IAS. My name is Pooja Dwivedi. There are two questions that we are going to find answers today for. First is the age of consent. Does India need to revise its age of consent? And the second one is the status of personal laws vis-a-vis the statutory laws of India. What are the answers to these two questions? We will know in today's segment. And this will be at the backdrop of a very important case. Moving ahead, if we talk about the different things that we are going to discuss under this segment today, the background of the case that we are going to discuss, what are personal laws? Constituent Assembly debates with respect to personal laws and position of personal laws in Indian Constitution, Muslim personal laws on marriage, what is the case we are talking about? And should India consider revising its age of consent, harmonizing personal laws and statutory laws, and the question in the last. So as we move ahead, first of all, we need to know the background of the entire situation. A young couple married against the wishes of their parents. The girl is a minor, and that has created the problem. Both belong to the minority community, both are Muslims, and when they sought protection from the SSP, they got no response as their life was in danger. They moved to the High Court. So the Punjab and Haryana High Court on 13th June, they ensured that the personal liberty of these two young persons remain intact, but the Punjab and Haryana High Court has been erroneous on its part according to POCSO. Now, a Muslim girl aged 16 or above was competent to marry a person of her choice in accordance with the customary law or the personal law as according to the Punjab and Haryana High Court. And the National Commission for Protection of Child Rights has said that by doing so, the High Court has endorsed child marriages. So they ignored, this NCPCR says that the judges ignored statutory provisions and legal principles which are laid down by the apex court in the past. Here it also says that it is against the POCSO Act as well as against the Prevention of Child Marriages Act of 2006. So what is this entire issue? We will delve into the detail of it. But first of all, let us talk about the personal laws. Personal laws, according to NIOS, is that branch of law which deals with matters pertaining to person or his or her family. And these actually lay down the principles according to different religions, which talks about marriage, divorce, maintenance, adoption, inheritance, guardianship, succession as well. And why are they actually law can be understood from the fact that laws are actually enforced by the administration. Article 13 Clause 1, here we have to talk about the definition of law. Law is the body of principle which is applied by the state through enactment or recognition to administer justice. Even if personal laws are non-statutory in nature, but they were in principle remaining in force, and because of that they came to be known as a law. So according to Article 13, as we know the definition of law, even customary practice can be said as a law. Personal laws could be considered an existing law or law enforced because of their applicability in the court proceedings. Whenever courts proceed on certain matters with respect to personal laws, they are taken into consideration, and that is why they can be touted as laws. Now, if we talk about the Constituent Assembly debates before Constitution came into force, when lot of debates and discussions were being done, of course, there were a lot of debate with respect to personal and customary laws. And these were, of course, for the draft of Article 35. Back then it was the Uniform Civil Code. Now it is enshrined in Article 44 of the DPSP. So, they said, first of all, we need to understand that we have to keep personal laws or not into the picture. Most members wanted to keep personal laws beyond the purview of the fundamental rights. This was the first thing. saying secular states like India must not indulge in controlling the personal laws through codification. Codification should not be done, and these should be left to the citizens to practice. As religion has been an integral part of the citizens of India, that can also be found manifesting itself in the revolt of 1857. So this was very much known to not only our colonial masters, but also to the free India, that the upcoming free India, that religion is a very integral part of the people's life. So it should be left to the citizens. But there are certain other people who thought that it should be codified. Here Munshi, for instance, said that state should have control over personal laws to bring objectives of the preamble into existence, such as equality. If every other community will have its own personal laws, equality and justice cannot be ensured. Apart from that, he also said that things like succession, adoption, inheritance, these all are not personal matters. These are more social in nature. So we should codify them. Dr. B.R. Ambedkar, his view was very unique. He was in favor of UCC, Uniform Civil Code, to some extent. But he was simultaneously known, it was known to him simultaneously that India is not ready for it. India did not develop that much of a forward mindset where they could abandon their personal laws and talk about them being dictated by some sort of other laws which were not known to them. Moving ahead, if we discuss the personal laws position with respect to constitution, why they are protected. Fundamental right to religion. According to Article 25 to 28 of the Indian Constitution, we can find that whenever there is an instance of protection of religion, the right to practice religion, propagate it, freely express it, then of course Article 25 to 28 comes into the picture. Then first, the Constitution makes all pre-constitutional laws void to the extent of non-conformity to the fundamental rights. That means if any customary law that existed before the Constitution came into force, if they are not conforming themselves to the fundamental rights of the country, they can be nullified. They will be nullified. If they do, then of course they can continue. And it also puts specific restriction on the state from making laws that potentially infringes fundamental right. Right to religion, enshrined in Article 25 to 28, says that protection of religion is of course, promised to all the citizens of the country. So, if we have to protect this promise, how can we infringe upon personal laws? So, they are protected in that sense. List 3 of the Indian Constitution gives the Parliament as well as the state legislatures to legislate upon instances such as inheritance, divorce, and adoption. And Article 44 talks about the Uniform Civil Code, as we all know. Uniform Civil Code has been much in the news. Where do Muslims get their laws from, personal laws from? First is the Quran, the first and foremost and the most important. Then we have Sunnah or Hadith. After that we have Ijma and Qiyas. There are also customs that dictate. It might not be written anywhere, but because the practice of something has been there since archaic times, then those can also be dictions. Certain legislations are also there which provide a legislative basis for Muslims, such as the Shariat Act of 1937, the Dissolution of Muslim Marriage Act 1939, and Muslim Women, this 1939, the Muslim Women Protection of Rights or Divorce Act of 1986, etc. These are certain examples. Moving ahead, sometimes it can also be seen that judicial decisions also dictate their laws. And justice, equity, and good conscience. If there is no mention of anything with respect to any practice, then good conscience can also dictate such laws. Moving ahead, if we talk about marriages in Muslim laws, basically Muslim personal laws, like in Hindus, marriages are sacrosanct in nature, but for Muslims, it's a civil contract. It's like a civil contract. The personal law suggests on marriages that every Muslim of a sound mind who has attained the age of puberty, that means age of 15 years or above, may enter into a contract of marriage. And in this case, the girl is 16 years of age. So, the Punjab and Haryana High Court sought that only. there should be a proposal made on or on behalf of one of the parties, and that should be accepted, and the words of proposal should be very clear-cut in nature. Alright, moving ahead. Now, the proposal and acceptance of marriage must be in presence of two male witnesses who must be Muslims and are of sound mind and nature. So, the couple about whom we are discussing today, they told the Punjab and Haryana High Court that we solemnize the marriage according to the Muslim personal law. As I have already told you that the Punjab and Haryana High Court did not say that we are validating the marriage. We are not going into the question of the marriage being valid or not. But as they are dreaded for their personal liberty and security, it should be known that protection should be given to them according to Article 21. Now let's move ahead and talk about POCSO. Now, on 3 grounds, the NCPCR has said that Punjab and Haryana High Court has not done correctly, and they have, went to the Supreme Court to challenge it. So, POCSO is aimed at shielding children from sexual abuse. Okay, and a child for POCSO is below the age of 18 years. The girl is 16 years of age. As for Prevention of Child Marriage Act of 2006, it prohibits marriage between two persons who are younger than 21 and 18 years of age, men and women. Again, as I say, the girl is 16. Punishment for those who abet, promise or solemnize such marriages will also be, there is a punishment for that. And also this particular case in which NCPCR has challenged the decision of the Punjab and Haryana High Court, they are saying that this is the violation of Supreme Court's 2017 judgment. In this judgment, the Supreme Court read down exception second of section 375 of the IPC, which before this decision guarded the men of any rape charges by their women. Okay, moving ahead, by their women. So husbands can also be charged for rape. Then the problem here is that the legal conundrum over the applicability of POCSO looms large. Why? Because in the current changing socio-economic scenario, we can say, teenagers are getting into a relationship by their own consent. So the problem is that if no revision takes place of the age, there will be many cases that will lead to acquittal and not conviction of the boy. So the POCSO will be applicable even in cases of consensual relationship with a minor. The problem is that if the girl is, suppose a girl is in a relationship with an older adult and she has consented to that relation, then her consent actually does not matter for POCSO, given she's below 18 years of age. So it does not differentiate between rape and consensual, relationship. The Kerala High Court lamented on that. It added that it would be in the interest of justice to settle the question of law. POCSO, NCPCR also seeks that once and for all, we should get over with this. We should ensure that the correct judgment prevails over such practices. Moving ahead, let us move ahead and talk about the Rama and Bande Rama versus State of Karnataka of 2022, in which the Karnataka High Court quashed the different charges that were on a man who was in a relationship with a minor. So here we can talk about the grey areas of age category 7 to 12. See, in our country, any act which is committed by a child below the age of 7 years is not an offense. That means the law states that a child does not know what is right or wrong if he or she is below the age of 7 years. Then the grey area comes into being by age 7 and 12. This is also the age between the age of 7 to 12. It is seen that children do not actually know what is right or wrong, what is an offense or not. That clearly means that after the age of 12, the child starts developing this outlook about what is right and what is wrong. Then we have Child Labour Prohibition and Regulation Act that defines a child as a person under the age of 14. A person who is below the age of 14 cannot be employed. And if the person has completed the age of 14, then what happens? They can be employed in various enterprises, if not otherwise. So that means if a person who has completed the age of 14 years develops, becomes more than a child, if not an adult. Many countries, they have 16 years or below as their age of consent. The high courts have time and again have said that we need to revise the age of consent because many American states, China, European countries, and Japan, Australia, these all fall in this category. Also, there is a need to define consensual sex as a separate category so that we can differentiate between what is mutual consent and what is actually rape. Moving ahead, if we talk about certain data, let us see, very interestingly, the NCRB data reveals that about half of the POCSO Act cases fall in the category of 16 to 18 years of age group. That means our society is changing. More and more people are being exposed to intermingling, exposed to intermingling. And this age is very normal for people to, explore new relationships. This is very normal. This is the reality. We cannot close our eyes on this. Now, in here, according to a survey, this is not according to NCRB, this is a separate one, okay? So, according to a survey, 1,715 romantic cases were registered under POCSO Act between the age of 2016 to 2020, and these were tried in the special courts in Assam, Maharashtra and West Bengal, in which 24.3% of the total cases were decided by the courts were of romantic category. Then, that means mutual consent was there. The parents and relatives of the girls constituted the 80.2% of the complainants, so that POCSO can also become a tool for harassing these young couples. Then in 85.5% of the cases, the girls said that the relationship was consensual. That is why many acquittals were done. In Vijayalakshmi versus State REP plus Rajkumar versus State of Himachal Pradesh, these two cases are well known for quashing and acquitting the accused, in which the court said that this POCSO Act was not a tool for harassing young couples. Then again in Rajkumar versus State of Himachal Pradesh, a person petitioned to the court that he does not want any case to go ahead for his son-in-law. So these are the certain things that we need to know. We have to harmonize the personal laws with respect to our statutory laws because it's important. Courts give a lot of time in such matters. The problem remains with interpreting the word law under Article 13 clause 1 because in the Narasu Appammalli versus State of Bombay, the Supreme Court decided that personal laws are not under the meaning of Article 13 clause 1. But in different other cases such as C. Masilamani Mudalai versus Idol of Sri Swaminathan Swami, Tirukoli and Geetha Hariharan versus RB. In these cases, the court, it undertook the responsibility of testing the personal laws based on fundamental rights to check their validity. If there is this much of divergence in the opinion, we need to at least harmonize them. The authorities, especially the legislative authorities, should need to understand that revision is important, a review is important with respect to such acts. Moving ahead, let us talk about our question for today. Consider the following statements with respect to National Commission for Protection of Child Rights. It was set up in March 2006 under the Commission for Protection of Child Rights Act of 2005. It works under the administrative control of Ministry of Women and Child Development. So we have to select which one of them are not correct. And let me take the names of those who have answered my last question correctly. Stay with me for a moment. So the correct answer was C, and many of you have answered it correctly, such as Anshika, Nidhish, Arun, Jyoti, Ashish, Lakshmikant, Neha, Vidyashri, Faizan, Shruti. Also, Shivani has answered it correctly, Saffrophile. Then Praveen has answered it correctly, Gaurva, Balaji, Ranjit, Muhammad, Tushita, Anil, Utkarsh, then Ravi Ranjan, also Archana, Sagar, Harish, Riya, Chahat, Naveen, Aditya Birla, Anuj. So please answer this question as well. I will try to take your names in the next segment. Thank you so much for watching.